morning, everybody, or good afternoon as we just crossed into the afternoon session. It's probably the most difficult time to speak when I'm keeping you away from lunch. But this is one right. This is the. I normally don't speak on designs. My area is patents or trademarks. But I thought I must share this particular topic with you because it is probably the most underutilized intellectual property right, particularly in India. It's something that is very strong, a quickly obtained right. For example, as we go along, I'll show you that this particular right is available in India in about less than 6 months. 6 months will be the outside. You get an intellectual property right in 6 months. And it's a very strong and effective right in taking actions as compared to the patent right or as compared to even trademarks or geographical indications as far as the enforcement is concerned. So I'll just rush through some of the slides. Essentially, one must understand that industrial designs, the right of designs, protects the external appearance of articles. Now, when we speak of external appearance of articles, it is not necessarily, earlier it used to be the whole article, but now the Indian Design Office and the Indian Design Registration Authorities have now considered even parts or components of articles. So if you have novelty, for example, in a part of an article, any article that one would speak of, a part of an article, one can protect it by under the Designs Act. And if that particular component is copied or infringed, or as we call it, piracy of design, we are able to then take action in respect of that. And I'll take you through some of the examples in the later slides. All that is required is the same requirements for patents. It has to be new, it has to be original, and unpublished before the date we make the application. As usual, we have 4 design offices. They are the same as the patent office. In India, the IP system has made these 4 jurisdictional offices. But for designs, there is only one examining authority, and that happens to be at Calcutta. India adopted the Locarno classification system, and it is not yet a member, as Alan said, it's not yet a member of the Hague Convention. But one particular aspect one must remember: with designs registered at the OHIM or the USPTO, in India there can be only one application for one design, and a design application can contain only one design. So if you have filed a design application at the OHIM with 10 designs, or at the USPTO with 10 designs, you will have to, that's a single application. In India, we must file 10 design applications separately. And for example, the closed view and the open view would be considered as 2 separate designs. Those of you who are dealing in design law, this must be borne in mind. And for example, therefore, I will need 10 priority documents for supporting each of those applications. It is the regulation, and we have to live with that. Now, I'll give you these would be traditionals. For example, a large number of designs have now been allowed for 2-dimensional articles. For example, carpets, textile sheets, and bags, and any prints of that service. But there is one area which I am now putting forth as a possible area for designs. That is probably the design of a home page for a website. I know we speak of artistic work, but it would, if we look at the design definition, which means 2-dimensional designs are permitted now in the Indian context. If a website page is made by an industrial process, if it is affected by an automated or a mechanical or an industrial or an electronic process, there is no reason why that should not be considered as an industrial design rather than an artistic work, which is the traditional way of looking at these. So for example, these would be pieces of jewelry, a toy, an automobile. So it's large to the small. You would have design registrations available for any of these types of articles. Now, what do we, for applying for a design in India, what would we need? I'm taking you through these slides because we must understand what is the background or the basis for the enforcement rights that are available. So what is important are either you can give actual photographs of the product, you can give line drawings, or you could give computer renderings of these images. Each of these three would be enough for obtaining a design registration in India. But we cannot give what are called the inner views, the actual engineering drawings or the sectional views of articles. It is very important that you pinpoint the novelty features. Sometimes this becomes an extremely relevant issue when we are dealing with enforcement actions. You must pinpoint that the novelty resides in, unlike the other design systems which are there at the OHIM or the USPTO, we here in India, it is important to pinpoint at the time of filing the actual novelty areas. The novelty resides in A, B, C, and D of that particular design registration at the time of the application, because then you can specifically take action against another person or an infringer if that is copied. Drawings for registration, for example, what are needed is, of course, the front view, the front perspective view, left side, back side, top. You take the article in generally 6 or 7 views. Now, if you make a statement like is made in this slide, that the novelty resides in the shape, configuration, and surface pattern of the chair, then it would reside. Then the design would be considered as registered as a whole. Again, the same kind of thing. Here is a photograph of cartons where that's been done. And again, when we speak of pattern of the rectangular container, so which means you are restricting your design to merely the rectangular container and none else. There are, of course, certain designs that are prohibited from registering. An important aspect is number D. D speaks of scandalous or obscene matter. If there is something of that nature, here designs of that type or which contain matters that would be objectionable or which are likely to hurt the religious sentiments of people, that would not be considered as registrable in India. Now, all designs, once they are registered, are now open to public scrutiny, and then they're of course open for cancellation proceedings. This is the important issue. For example, it's a very reasonably costing right. You can get a design right in around $300 to $400 is the cost for obtaining a design right, and it is obtained within 6 months. So you can get within 4 or 5 months the design right is obtained, and you can enforce immediately thereafter. Now, as opposed to that, for example, a patent right is anything to up to 4 years. And it would cost anything to up to $3,000 to $4,000 is the total cost of obtaining a patent right in India until final grant. Now, if this is the position, now again trademarks we are talking about 2 years, minimum amount of 2 years and about $700 to $800 as far as the trademark cost. So it is the least expensive of the big intellectual property rights that are obtained, and the fastest, and let's as I take you to some of the cases, very legally enforceable right. Of course, like other rights, like other statutory rights, designs are subject to cancellation. So which means if you have obtained the design wrongly, if you have obtained the design incorrectly for any of these reasons, the design right itself can be cancelled. And an important area for people to understand that the assignment deeds, if you are going to assign a design from an inventor to an assigner, or from one assigner to an assignee, the assignment must be complete within 1 year. If it isn't completed, and that is a requirement of its peculiar design requirement, you can't wait beyond the 1 year, otherwise you have to go through the entire assignment process all over again. As far as the design right in India is concerned, we have only civil remedies. As you know, there are two types of remedies, the criminal remedies and civil remedies. And for other intellectual property rights, for example, trademarks, copyrights, we have criminal remedies also available. You can go to a criminal court and enforce or punish the infringer. In India, for patents and designs, we have only civil remedies available.